Hello, my name's Daryl Wellberg, and I am a Jehovah's Witness in good standing. Now this video is going to be a two-parter because it's on child molestation and the two-witness rule that's provided by Jehovah God in his Bible. Now, this video is not approved by the Watchtower Bible and Tract Society of Pennsylvania, although it should be. It's not approved by the 8 faithful members of the governing body that take the lead among the Jehovah's Witnesses throughout the earth. They're located in Warwick, New York, and it's not approved by any local body of elders. I work for Jesus Christ, and he approves of this video. Now today, there's a question as to the method that Jehovah's Witnesses use with sexual predators. And I should say alleged sexual predators. We're not scientists, we're not forensic scientists, and we're not investigators, at least to the point of being a criminal investigator. But for the sake of the organization, the congregation, we do have elders that do some investigation. But of course their investigation is limited to their expertise. Now, what I would like to do first of all is ask for you to join me in your Bibles. And you know, it's unique because I'm going to post a read from the New World Translation of the Holy Scriptures, which just happens to be the most accurate Bible in print, but you can use any Bible you want because they all say basically the same thing here. And today, if you could, rendezvous with me at Deuteronomy, and we're going to begin in chapter 17 in verse 4. That's Deuteronomy chapter 17 and verse 4. And we're going to go on to verse 6. Are you there yet? I hope so. When it is reported to you, or you hear about it, then you should investigate the matter thoroughly. If it is confirmed to be true that this detestable thing has been done in Israel, you must bring the man or the woman who has done this evil thing out to the city gates, and the man or the woman must be stoned to death. On the testimony of 2 witnesses or 3 witnesses, the one who is to die should be put to death. Now look at this cautionary detail here. He must not be put to death on the testimony of 1 witness. Now, if you will, please turn with me again, and that same, just a couple of chapters down there, to chapter 19. That's Deuteronomy chapter 19, and we're going to consider verses 15 through 21. And it reads, "No single witness may convict another for any error or sin that he may commit. On the testimony of 2 witnesses or 3 witnesses," as the other verse provided, "the matter should be established. If a malicious witness testifies against a man and charges him with some transgression, the 2 men who have the dispute will stand before Jehovah, before the priest and the judges who will be serving in those days. The judges shall thoroughly investigate." Again, thoroughly investigate. "And if the man who testified is false witness and has brought a false charge against his brother, you should do to him just as he had schemed to do to his brother. And you must remove that what is bad from your midst." Those who remain will hear and be afraid, and they will never again do anything bad like this among you. And verse 21, you should not feel sorry. Life will be for life, eye for eye, tooth for tooth, hand for hand, and foot for foot. Now, if you will, please, again, turn with me in your Bibles to Matthew. And now we're going into what some of you call the New Testament. And let's meet at chapter 18. And we're going to consider verses 15 through 17. Moreover, if your brother commits a sin, go and reveal his fault to him, between you and him alone. If he listens to you, you have gained your brother. But if he does not listen, take along with you one or two more, so that on the testimony of 2 or 3 witnesses every matter may be established. If he does not listen to them, speak to the congregation. If he does not listen even to the congregation, let him be to you just as a man of the nations and as a tax collector. When it says congregation there, it's not talking about bringing the matter in front of all the congregants. It's talking about the body of elders, of course. Now, this is a very important question Bible readers should ask at this juncture. Why did Jehovah God and Jesus Christ remind us that the 2-witness rule was always in effect from day one all the way down to today? Along with investigation. Well, the following will address why. Headlines. Newspaper. Dad sentenced to 50 years, freed his family dog, reveals daughter's lie. And I've got the links are down below. And the daughter claimed the dad threatened to kill her dog Lucy if she told anyone that he molested her, and that the dad eventually killed her dog anyways. Well, after the dad was granted a new trial for other reasons, the Innocence Project located Lucy the dog. This is just but another reason why the 2-witness law is necessary. Now, when I say 2 witnesses, it doesn't necessarily have to be 2 human witnesses. Again, investigate thoroughly. Remember that, Deuteronomy? In 1986, a defendant was convicted of 4 counts of first-degree sexual offense and ordered to serve 2 life sentences. In 2001, after spending 14 years in prison, this defendant was released. 2 years after his daughter admitted that she lied about her father molesting her. Now, although a medical examiner had found no evidence of defendant's alleged sexual abuse, there was no forensics. The daughter's story was so convincing that it held up until she finally admitted to the falsehood. Her excuse? She had lied to escape her strict religious upbringing. The cost? 14 years of freedom. 14 years. And this man's reputation. His life was irreparably harmed. This is why we should go by the 2-witness rule along with forensics. A similar case occurred in 2004 when, after spending 12 years in prison, the defendant walked free. The defendant had been sentenced to 40 years in prison in 1992 for molesting a 3-year-old girl. A few years ago, the alleged victim found out that the defendant was in prison and told a relative that she had been coerced into lying to authorities. Apparently, another relative who had harbored a long-standing grudge against the defendant had coached the girl. The 2-witness rule prevents these false accusations. Sadly, false accusations of molestation are frequent, even more so today than they were back then. Besides detracting from the credible cases of true sexual abuse, false accusations have put many innocent men and women behind bars, while destroying their families and ruining their lives. The motives for manipulating a child into making a false accusation can range from revenge over a broken relationship to a desire to gain full custody of a child, and in cases where there are huge sums of money at stake, or in cases involving celebrities such as Michael Jackson and others. The motives often include a desire to obtain a financial windfall from a public figure. After spending 20 years in a California prison after a 1985 child molestation conviction, one defendant was released on his 61st birthday. 4 of the defendant's accusers, now adults, testified that overzealous criminal investigators manipulated them until they fabricated the stories of abuse. Doctors had never even examined the victims. There was no forensics. The defendant's case demonstrates a classic case of nervous and over-anxious child care officials fearing the legal consequences of failing to protect a truly abused child, only to overreact and lead children into false accusations of molestation. Even when the two-witness rule is applied, some can still be falsely accused and sentenced to prison. Another headline, daughter, I lied and sent my dad to prison for rape. Yeah. In this case, the 9-year-old daughter was coerced by a drug addict mother to accuse her father of rape. No forensics, no other witnesses. The father was found guilty and sentenced to 40 to 50 years in prison. Now keep in mind here that a doctor did, in this case, examine the girl. And he provided that the daughter's hymen was intact, and yet the daughter claimed that her father had penetrated her. He spent 16 years in prison. Now the forensics was the witness that disproved the daughter. But the jury, they're idiots. That jury were idiots. No second witness. The father should have been exonerated by that jury. Testimony is not enough to convict. It simply isn't. Folks, I'm sorry, but it's not. Sadly, in the Candace Conti case that many of you apostates are well aware of, only her testimony exists to accuse a man of molestation when she was 9 years old. For some unknown reason, she had been on an internet sex offender's website, and she saw this man whom she knew to be a Jehovah's Witness, and in fact this man had gone out with some of the group, with the same group that she had went out with on several occasions in the ministry work. Now Conti then saw the cha-ching-ching dollar signs flash. She went to a lawyer who advised her on how to proceed. She claimed that Kendrick, is the fellow's name, molested her repeatedly when they went out in the ministry work alone. However, she never told her parents. She never told the elders of the congregation. She didn't tell the police. She didn't tell any school officials. She didn't even tell a best friend. She kept it in for some 20 years. Of course, when she went to the lawyer, he told her to go to the elders because he wanted evidence that they weren't going to do anything. And then when that didn't work and the elders told her there's nothing we can do, this was 15, 20 years ago, whatever how long it was, she went to the police and they told her basically the same thing. Now I believe her lawyer was the one who sent her to the elders and to the police. And I believe she's a con artist. The victim was the Watchtower Bible and Tract Society of Pennsylvania, the legal entity that oversees the finances of the Jehovah's Witnesses. But Candace Conti is not a victim. All you have to do is look at her videos. There's 2 individuals. In fact, that John Cedars idiot, Lloyd, whatever, Evans, whatever his name is, he made a 4-part video, and this George guy made a 4-part video. But the real damning video was the ABC video. And you can Google it. The lack of evidence typically presented leads to very few avenues available for an innocent person to challenge their conviction. And the joint project by the University of Michigan School of Law and the Center of Wrongful Convictions at Northwestern University School of Law, the National Registry of Exonerations released a report examining exonerations between 1989 and 2012. Of the 102 exonerations for child sex abuse cases, the report released the following statistics to account for what led to these individuals' wrong convictions. 26% were mistaken witness identification, 26% of the cases. 74% of the cases for perjury or false accusation, 7% false confession, 21% false or misleading forensic evidence, and 35% official misconduct. In addition, the report also states that child sex abuse exonerations primarily involve fabricated crimes. The false accusations are by large produced by pressure on the children from relatives, police officers, therapists. These accusations generally unravel when the witnesses recant. And I think we can safely add lawyers to the above addition for reasons to overturn sexual abuse cases. Now I wonder if Candace Conti would not recant. Fortunately, Conti's only victim was the Watchtower Bible and Tract Society of Pennsylvania, and a $2.8 million windfall, which she got very little of. The lawyers took most of that. The only reason the jury sided with Conti is that Kendrick admitted sexually molesting his stepdaughter and granddaughter, and, for the most part, the fact that Jehovah's Witnesses annoy them on the weekends when they are trying to sleep in or relax. There was no evidence in the Conti case that she was ever molested. January 31st, 1990, the McMartin preschool trials. Amazing. The McMartin trials had already taken over 6 years and cost more than $13.5 million without a single guilty verdict, resulting from 208 charges. A jury had deadlocked on 13 charges. Now, that deadlock vote was 11-2 for acquittal against Buckley, the male in it. But prosecutors didn't want the matter to drop, so they decided to retry him on 8 of those counts. The McMartin prosecutions represented the height of the hysteria over sexual abuse in the 80s. Despite a complete lack of reputable evidence against the teachers and workers at McMartin Preschool, and with every indication that the children had been coerced and manipulated into their testimony, the prosecutors nonetheless proceeded against Ray Buckley for more than 6 additional years. Believe the children, which a lot of you apostates want to believe Candace Conti. And that's the only evidence you got is Candace Conti. And besides, Jonathan Kendrick passed. Believe the children became the mantra of advocates who insisted the children never lied or were mistaken about abuse. The courts made unprecedented changes to criminal procedure to accommodate this mistaken notion. California Supreme Court ruled that the child witnesses were not required to provide details about the time and place of the alleged molestation to support a conviction. Out goes the Sixth Amendment to the United States Constitution because the U.S. Supreme Court held that a child witness could testify outside the courtroom despite the Sixth Amendment's clear command that a defendant has the right to confront his or her accusers. Throughout this nation, parents and daycare workers were jailed after false and often absurd allegations about child sexual abuse. As this hysteria swept the country, abuse counseling quickly became a cottage industry, attracting often unqualified people who seemed to find sexual abuse everywhere. Recent research has found that young children are exceptionally easy to manipulate. Even when only subtly suggested, a child will respond with the answers he or she believes that a questioner wants to hear. That was abundant in the Ray Buckley's case. Now, Buckley's retrial went much faster than the original. By July, the jury had acquitted on 7 charges and were deadlocked once again, the majority voting for acquittal on the other 6 accusations. The district attorney then decided to drop the case. After this man was put through the ringer for, 20 years? Now, the McMartin preschool case was one of the earliest and largest child sexual abuse cases in the country. None of the charges were ever convicted. None of the charged. None. Not a single one. And this case is often cited as triggering the wave. That case began in 1983 when the mother of a 2-year-old boy, 2.5-year-old boy, reported to police that her son had been abused by Raymond Buckley. McMartin Preschool was in Manhattan Beach, California, an affluent community. And Ray was the only male teacher at this preschool. But they charged Virginia McMartin in her mid-60s, his own mother, Peggy McMartin Buckley, she was an administrator, and him. After the initial accusation, Ray was arrested but released due to lack of evidence. The mother continued her allegations, coming to the police station all the time, wrote letters to 200 parents, the police did. After the letters were sent out, parents began questioning their children, and children began telling stories of abuse at the preschool. They had been tortured, touched, inappropriately. Their pictures had been taken. They had been forced to engage in anal and oral sex and forced to play a game called Naked Movie Star. Dozens of the children were interviewed and examined by therapists specializing in diagnosing sexual abuse. They indicated that Peggy and other teachers, as well as Ray, at the time went on, and the accusations mushroomed from sexual abuse to include stories of bizarre satanic rituals, McMartin's mutilated animals, forced the children to touch corpses, they had a hidden underground passageway beneath the school, but no such passageway was ever found, and some of the children's interviews were videotaped and shown to jurors at trial. 1984, the police arrested Ray, his mother, his grandmother, Virginia, Peggy and Virginia, as well as 3 other teachers. Now, the charges against Virginia and Peggy and other teachers were dropped in 1986 for the lack of evidence. Of course, the first trial of Ray and his mother began in 87, ended in 89 with acquittals. Now, Ray himself was tried again, and by 1990, another jury was deadlocked on all counts. And the prosecutors chose not to try him again. Ray had spent 5 years in jail, and Peggy had spent 2. Now, that lengthy and sensational McMartin case drew attention from the national media and is still cited today as a symbol of the dangers and difficulty of using children's testimony. Some jurors in the first trial, when interviewed after the verdict, said that it was the videotapes of the interviews with the children that had prevented them from finding the McMartins guilty. They said that they believed that some of the children had been abused, but that the interviewing techniques had been so suggestive that they had not been able to discern what really happened. Fells Acres Day School, 1986 and 1987. Malden, Massachusetts. Violet Amirault had been running the Fells Acres Daycare Center for almost 20 years with her children and 5 other teachers when her son Gerald Amirault was accused of abusing children in their care. Gerald was not a teacher, but he helped out at the school as a handyman and bus driver. That incident prompted a large-scale investigation, and 2 trials with multiple appeals occurred in 1984 when a 5.5-year-old boy told his uncle that Gerald had touched his private parts. According to Gerald, the boy had wet his pants, and in order to help out the boy's teacher, who was busy, Gerald took the boy into the bathroom, dried him off, and gave him a fresh change of clothes. Now, the boy's mother claims that soon after the incident, he began displaying disturbing behavior, wetting his bed, baby talk, chronic masturbation, and acting out sexually with his younger brother. She became concerned, and rightly so, and asked her brother, her own physical brother, who had been sexually abused as a child, to talk to her son. During a walk in the park, the boy told his uncle that while he was at school, Gerald had pulled down his pants and touched his penis. The mother started questioning the boy about what happened to him at daycare. Eventually, he told her that Gerald often took him to a secret room with a bed in it, or to the park where he would undress the boy and fondle him. He also said that Gerald put his own private part in the boy's mouth and in his rectum, and indicated that other children were abused as well. The boy's mother kept calling the state's child abuse hotline. Well, Gerald was arrested a few days later, accused of raping a child. The school was closed 3 days after that. On September 12, 1984, a meeting was held at the town where the police and about 65 parents had gathered. They were discussing the situation at Fells Acres. The police encouraged the parents to question their own children about what happened, and to be persistent if the children did not initially disclose abuse. And they asked the parents to question their children about the existence of a magic room and a clown, and advised them of behavioral symptoms believed to be consistent with sexual abuse. Now, after this meeting, more children began to disclose stories similar to the first boys. Parents, even some who had not been present at the controversial meeting, began noticing emotional and physical disturbances and sexualized play among many of the children. Now, children started to tell stories of an abuse, a magic room, a clown, a robot. One girl said Gerald had penetrated her private part with a 12-inch knife. Other children claimed they had been raped by a clown, tied to trees while naked, photographed, and forced to watch animals being killed. Eventually, 41 children aged 3 to 6 years old made accusations of abuse against the Emeralds. Now, Gerald was charged with molesting 19 children, Violet and Cheryl, his sister, with abusing 10. The Emeralds were tried in 2 separate proceedings, Gerald in 86 and the 2 women in 87. A testimony of 9 children was used in Gerald's case. 4 children testified against Cheryl and Violet. In both trials, the children testified in an unprecedented seating arrangement, in violation of the Sixth Amendment to the U.S. Constitution. They sat in special child-sized chairs and desks directly in front of the jury. The defendants were placed off to the side so that the jury could see them, but they could not make eye contact with the children. This unusual arrangement was devised to reduce the trauma of testifying for the children. Later, members of both juries said that the children's testimony was a major influence in their decisions to convict. In addition to the testimony of the children, prosecutors also pointed to physical evidence of abuse on 5 of their 10 children, citing vulvitis, vaginitis, a small scar on one of the girls' hymen, and a well-healed anal fissures on some of the children. All of the Emeralds were convicted. Violet and Cheryl were sentenced to 8 to 20 years in prison, Gerald to 30 to 40. In 1995, after 8 years in prison, Cheryl and Violet were released when the state Superior Court overturned their conviction and granted them a right to new trial based on the unusual seating arrangement of the children, finding that the arrangement had violated their right to confront their accusers face to face. Now, a different judge, the one who had initially approved of the seating arrangement in the 1986 trial, rejected a similar argument in Gerald's appeal. However, in March 1987, 2 years after their release, the state Supreme Court vacated the order for a new trial, and they reinstated Cheryl's and Violet's convictions, citing the need for finality instead of whether or not the people were criminally responsible. They wanted to get final judgment in criminal proceedings. They wanted the case to end. The court did note that some of the original investigatory practices were unsatisfactory. Now, the mere fact that if the processes were redone, there might be a differing outcome, or that some lingering doubt about the first outcome may remain, cannot be a sufficient reason to reopen what society has a right to consider closed. That's what the court wrote. In April of 1997, the Emeralds' lawyers filed a motion for a rehearing, asking the Supreme State Court to reconsider its decision. The following month, a lower court judge ordered a new trial for Violet and Cheryl, and they were released on bail, but Violet died of cancer a couple of months later. And this brings an end to part 1, and I hope you tune in to part 2 that will be coming up shortly. And I want to thank you for following this. because I know your time is valuable to you just as my time is. But the two-witness rule has to be in place according to Jehovah God and Jesus Christ, for the Jehovah's Witnesses at any rate. Thanks for watching this video.